of the group or organization is considered proved and shall not be questioned. Unquestionably, it would have been competent for the charter to have declared flatly that membership in any of these named organizations is criminal and should be punished accordingly. If there had been such an enactment, it would not have been open to an individual who was being tried for membership to contend that the organization was not, in fact, criminal. But the framers of the charter, acting last summer at a time before the evidence which has been adduced here was even available to us, did not care to find organizations by fiat. They left that issue to determination after relevant facts were developed by adversary proceedings. Plainly, the individual is better off because of the procedure of the charter, which leaves that finding of criminality to this body after hearings at which the organization must and the individual may be represented. It is at least the best assurance that we could devise that no mistake would be made in dealing with these organizations. Under the charter, groups and organizations named in the indictment are not on trial in the conventional sense of that term. They are more nearly under investigation, as they might be before a grand jury in Anglo-American practice. Article 9 recognizes a distinction between the declaration of a group or organization as criminal and the trial of any individual member thereof. The power of the tribunal to try is confined to persons, and the charter does not expand that term by definition, as statutes sometimes do, to include other than natural persons. The groups or organizations named in the indictment were not as entities served with process. The tribunal is not empowered to impose any sentence upon them as entities. For example, it may not lay a fine upon them, even though they have property of the organization, nor is it to convict any person because of membership. It is also to be observed that the charter does not require subsequent proceedings against anyone. It provides only that the competent national authorities shall have the right to bring individuals to trial for membership therein. The charter is silent as to the form that these subsequent trials should take. It was not deemed wise, on the information then available, that the charter should regulate subsequent proceedings. Nor was it necessary to do so. There is a continuing legislative authority representing all 4 signatory nations, competent to take over where the charter leaves off. Legislative supplementation of the charter, of course, would be necessary in any event to confer jurisdiction on local courts, to define their procedures, and to prescribe different penalties for different forms of activities. Fear has been expressed, however, that the charter's silence as to future proceedings means that great numbers of members will be rounded up and automatically punished as a result of a declaration that an organization is criminal. It also has been suggested that this is or may be the consequence of Article 2, 1D of Control Council Act Number 10, which defines as a crime, quoting, membership in categories of a criminal group or organization declared criminal by the International Military Tribunal. A purpose to inflict punishment without a right of hearing cannot be spelled out of this charter and would be offensive to both its letter and its spirit. And I do not find in Control Council Act number 10 any inconsistency with the Charter. Of course, to reach all individual members would require numerous hearings, but they will involve only narrow issues. Many persons will have no answers to charges if they're carefully prepared, and the proceedings should be expeditious, non-technical, and held in the locality where the person accused resides, and incidentally may be conducted in 2 languages at most. But I think it is clear that before any person is punishable for membership in a criminal organization, he is entitled to a hearing on the facts of his case. The Charter does not authorize the national authorities to punish membership without hearing. It gives them only the right to bring individuals to trial. That means what it says. A trial means there is something to try. The Charter denies only one of the possible defenses of an accused. He may not relitigate the question in a subsequent trial whether the organization itself was a criminal one. Nothing precludes him from denying that his participation was voluntary and proving that he acted under duress. He may prove that he was deceived or tricked into membership. He may show that he had withdrawn. He may prove that his name on the rolls is a case of mistaken identity. The membership which the Charter and the Control Council Act make criminal, of course, implies a genuine membership involving the volition of the member. The act of affiliation with the organization must have been intentional and voluntary. And it presents both statutory and juridical examples of declaring organizations to be criminal. Statutory examples are the German Criminal Code enacted in 1871. Section 128 was aimed against secret associations, and 129 against organizations inimical to the state. A law of March 22nd, 1921 against paramilitary organizations. A law of July 1922 against organizations aimed at overthrowing the Constitution of the Reich. Section 128 of the Criminal Code of 1871 is especially pertinent. It reads, "The participation in an organization, the existence, constitution, or purposes of which are to be kept secret from the government, or in which obedience to unknown superiors or unconditional obedience to known superiors is pledged, is punishable by imprisonment." It would be difficult to draw an act that would more definitely condemn the organizations with which we are dealing here than this German Criminal Code of 1871. I recall your attention that it condemns organizations in which obedience to unknown superiors or unconditional obedience to known superiors. Exactly the sort of danger and menace with which we deal here. Under the Empire, various Polish national unions were the subject of criminal prosecutions. Under the Republic in 1927 and 8, judgments held criminal the entire Communist Party of Germany. In 1922 and 28, judgments of the courts ran against the political leadership corps of the Communist Party, which included all of its so-called body of functionaries. This body of functionaries in that organization